The next, Stephanie Alexander. She works for Trips in Florida. So she came flying all the way over the Sunshine State to give a presentation here. So please, it should be the biggest applause of the conference of the night.
Oh, thank you very much. My name is Stephanie Alexander, and I want to thank Bas and the other org of the event. It's been fantastic, and I've learned so much from all the speakers. As Bas said, my name is Stephanie Alexander, and the title of my talk today is Bitcoin a Legal System? A little bit about me. As he said, I'm a partner at the law firm of Tripp Scott. I've been a lawyer for more than 20 years. I got my bachelor's and my law degree from the University of Chicago. I'm a former law professor. I taught secure transactions, which is a lot like smart contracts in the sense that secure transactions contract is secured by collateral. I also taught legal skills and values for many years, which is basically I taught lawyers how to be lawyers. I'm a cryptocurrency enthusiast. I got involved a couple of years ago on the internet, obviously, and then I started watching some of Mike Hearn's videos on smart contracts and other type products that are Bitcoin, and I was really blown away by the disruptive potential that Bitcoin has, not only for the financial industry, but also for the law, which is really what I'm concerned about. Since that time, I've started as a lawyer representing some startup crypto clients, also talking to current clients of our firm about transitioning and accepting Bitcoin, and also starting to interface with state regulators who are trying to figure out what it is and how it should be regulated and if it should be regulated. And so that's really my place in the space, as it were. And I'm known as Bitcoin Mama on Twitter, if anybody wants to look me up there. It's actually, I just picked it so that it would be easy to remember. And it's actually had some interesting impacts in some of the forums that I participated in online. My presence in the room as Bitcoin Mama has really kind of a moderating influence. People are less likely to curse, for example, and say other untoward things if they know in the room. So that was just a side effect of picking the name that was unedited. I'm a lawyer, as I said, and I am not a coder. I don't know enough about the technical side. I can barely understand private key wallets and blockchains, but I do have a rudimentary understanding. I have a great respect for the coders who sit and try to draft applications for the Bitcoin space, because I know it can be incredibly difficult. As a lawyer, though, I feel like since smart contracts and other stuff that we'll talk about have a lot of legal implications, it's great to have input from a lawyer from the legal side, because we deal with dispute resolutions and the other kinds of contracts that go hand in hand with the Bitcoin system. So the title of my talk, as I've already said, is Bitcoin a Legal System? Now you might be saying to yourself, well, that's an odd question, right? Because as we all know, I put forth a simple definition here. Bitcoin is a decentralized and distributed software that allows for the relatively quick and frictionless transfer and recordation of financial and other informations. So again, is Bitcoin a legal system? Well, it's really about the transfer of information. As Andreas Antonopoulos says, money is really the first app of the Bitcoin protocol. But if we look closer, we see that the Bitcoin protocol from Satoshi Nakamoto himself has built in a lot of capabilities that have already been programmed into the system. As you all know, smart contracts, mediation, title transfer and recordation, will recordation, and asset transfers, right? Back and forth. Looks a lot like many of the features of common legal systems. Why? Why was that built into the Bitcoin protocol? You must be asking yourself. Well, I think for a couple of reasons. The first is, and most significant from a commercial standpoint, that because Bitcoins are irrevocable when spent, there needs to be some mechanism for the payments by Bitcoin to be conditional in some sense, or to be reviewed by a mediator, or to have other dispute resolution built in, because people don't want to spend large amounts of Bitcoin on something that may not happen, or where they may not get the goods they were promised and not be able to get them back. So it's a significant, I think, drag or limitation Bitcoin protocol that the coins are irrevocable. So the fail-safe was sort of built in, and that's where we get smart contracts and conditional payment properties of the protocol. But the other issue too is, if you think about it, what is Bitcoin designed to do? Well, it's designed as a protocol to disintermediate the financial system, right? To take out the banks and financial institutions as intermediaries and allow people to contract with themselves, to transfer value amongst themselves. Okay? So, let's look at the judicial system. Legal systems are just like banking, right? In the sense that the judicial system operates as trusted intermediaries in the same sense as banks do, just in a different arena. The courts provide judicial services to two opposing parties, just as banks generally provide financial controls between two parties in commercial transactions. So there's a lot of similarities. So the protocol, I think, in addition to the irrevocability issue, was crafted with so many legal features because there are perceived in most legal systems that echo the deficiencies that the protocol was designed to address in the financial area. For example, legal systems are centralized, they're local, they can be slow, costly, inefficient, and there's always risks of judicial error. Even if you get the world, there's a chance that the judge may get it wrong. There may be conscious bias towards one of the parties, or the judge may just not understand. So there are risks to this centrally controlled, just like there are risks in the financial system, and they really are very similar. With respect to costly, inefficient, and slow, not all legal cases are like that. Some get resolved expeditiously, some get resolved in the best manner possible. But I remember just after law school, I clerked, luckily or unluckily, picked to be on a jury in Chicago in a contract case. The case had taken 10 years to get to trial. 10. A lot of the witnesses didn't even have any recollection anymore. Back to contemporaneous evidence, their notes, to remember what the heck had happened. And even though it was a contract of 10 pages, the trial itself on that contract and who should win took 2.5 months. That shouldn't happen. And in a lot of cases, the judicial systems are better than that, but they can be slow, costly, and inefficient. Now, as we've had questions earlier today, to address the deficiencies and to address the needs of the protocol, the required party mediation and smart contracts, there have been a rise of newer, what I call quasi-legal crypto protocols. Ethereum is probably the most notable. I'm a fan. Open transactions, BitHalo, which requires both parties, as I understand it, to pay deposits. Counterparty, Clear, Ripple, next. There's quite a few, and there's probably some that I've missed. Those are just the ones that I know off the top of my head or I've read something about. But there are still deficiencies in the way that the protocol resolves the issues related to conditional payments and the need for some authority or reviewer to decide in contested cases who's going to get the Bitcoin transaction. So currently the Bitcoin protocol does not provide any guide decision maker or the mediator that's appointed under a multi-sig transaction as to the legal principles that should be used to decide the dispute. Enter into a multi-sig transaction. I want to buy a book. It's an expensive old first edition, and I appoint a mediator who's supposed to decide. The two of us have the better side in a dispute. Well, how is that person that we appointed supposed to resolve the underlying issue? Are we just going to rely on their native intelligence? Do we flip a coin? We probably do, right? If I'm in that transaction and I realize the mediator is likely to flip a dispute, I'm probably not going to pick them. So it's important, I think, that there be some overlaying guidance as to how multi-sig mediators are going to resolve disputes that come up. And also, another issue is that the protocol is silent whether additional damages are available if there's a breach in a transaction involving cryptocurrency. And that could be important because, for example, if, and it goes back to some of the earliest report cases, if I have a business and I'm buying that keeps my business going, and you take 2 or 3 months to provide the part to me and my business goes under because of your delay, you'd be responsible for the additional damages that you caused me. Now I know some people, well, that's antithetical to the whole principle of cryptocurrency, right? All these damages and other things. But you have to realize, if our goal is currency accepted in the world commercially as a viable, significant material option, it has to provide these mechanisms, or people with a lot of money or a lot of significant transactions are not going to migrate to the cryptocurrency sphere. Or they may, but only in a limited fashion. They'll use cryptocurrency or Bitcoin to pay the underlying transaction, but they'll have another 20-page contract on the side in case there's a problem. What we do know from the law perspective is that strict legal rules don't work. So you can think, well, I'll just have a smart contract. But the way the world works in reality is Murphy's, right? So you can contract for 20 different possibilities that could have action, and the 21st is the one that's going to actually come. And chances are your smart contract has not addressed that possibility. Because what happens a lot of times in contract breaches, from a perspective, is that one side or the other has expectations that didn't really get expressed sufficiently, either implicitly or explicitly. Or what also happens oftentimes in contract disputes is that some outside event came into play that was foreseen highly unlikely. And so it wasn't contracted for. And so ultimately the legal question that has to be asked when you're left with a broken transaction in a highly unlikely event that has occurred is, who's the better risk bearer, right? Based on that transaction and what we know about it, and given the odd thing that just has happened, who should lose? So basically the literal enforcement is unworkable because we can't anticipate the full range of facts to which the rules will. So, the quasi-legal features of the current Bitcoin protocol are insufficient because there's no conceivable set of rules that could unambiguously cover all of the activities. The more rigid a law is, the more over and under-inclusive it will be. So, in sum, the Bitcoin protocol either capture, which means provide flexible analysis of fact-intensive disputes, to provide a genuine ability to be heard, which is a dignitary issue, less than I think a lot of the talk about smart contracts. There's a real value in feeling like someone has heard you that's lost if it just goes back and forth as a computer program. And the other issue is that the protocol is currently drafted. It can't provide complete redress in terms of damages because, like I said, it doesn't deal with should there be consequential damages if additional damages have been caused to the non-breaching party. So basically, it leaves the underlying commercial agreement incomplete and can't really resolve the dispute. So in my view, what the legal cryptosphere needs is a coder system of principles adapted to the cryptosphere that provides decision-maker guidance, more complete remedies, and mechanisms for voluntary. So let's get back to the original question that I posed in the beginning. Is Bitcoin a legal system? The answer to whether the Bitcoin protocol is a legal system is that it is one, but it's really an incomplete one. Still, a crypto blockchain or perhaps a side chain can be used to disrupt the law in the same ways that Bitcoin has disrupted the financial. That is, the promise of the blockchain can be used to create a voluntary legal system that's faster, cheaper, fairer, more efficient, and more specialized than current systems with respect to commercial transactions. So, by that I'm saying, we're not just concerning ourselves with creating smart contracts or title registers, but an entire new legal system. So where should we start if we're going to create like that, like a specialized legal system for cryptocurrency contracts and commercial transactions? Well, my view is that we should stand on the shoulders of legal codes and legal thinkers of all time and make a better, faster, and more responsive for sophisticated commercial disputes. This is better for clients and for society and justice. So I asked myself when I thought about this question, have there been situations where things like this, or legal codes or legal systems like this have evolved in special areas? Well, of course, there are lots. If you think about the law of the sea, which is the law of the high seas, has a lot of parallels because it's like a sea, in a sense, with little ships going back and forth. But what I find that is most useful, and we're actually going to go back to the Middle Ages to come back to the present, is a legal system called the lex mercatoria of pipe powder. And the lex mercatoria was a commercial system adapted to the specific needs of the Middle Ages in port towns and fair towns. So if you were in a medieval port and you were selling your wares and someone tried to cheat you out of money, or there was a dispute over the transaction, what would happen, you wouldn't wait 6 months or a year to go to court under the common laws or the civil laws. That really didn't work for you. Your transaction had to be quicker. Your legal system had to be quicker. So the lex mercatoria evolved in those areas, the ports and the fair towns, in order to provide expeditious judicial resolution of commercial disputes, because it was required that they were to be quick. So what would happen was, they were called the courts of pipe powder in England because the litigants would often come in with dusty feet. They had pipe powder on their feet, and they would, so what would happen was there was a dispute. Dispute was over, let's use our pipe powder of flour. If the dispute was over flour, they would quickly pick a judge who was specialized in flour and knew something about flour. Both sides would come in, they would tell their version of the events. The judge was required to issue a decision within 3 tides, which was basically a day and a half. So my view is, if they could resolve a case in a day and a half in the Middle Ages, when they didn't have computers or the internet, we could decide commercial cases in way less than the year that it typically takes, at least in my jurisdiction, to resolve this.
Good idea.
These are my preliminary thoughts. I think as the cryptosphere, it's so early, as it evolves, there's going to be some nuances and some changes possibly, but this is where I am. What would this, what I call the lex cryptotoria, look like? Well, it would provide for the quick and frictionless crypto economy and provide quick and frictionless legal systems. So here's what I'm thinking. Somebody has a cryptocurrency dispute over a significant commercial transaction. They've either elected into the system because they're using cryptocurrency, or it's part of a smart contract and it's built in. If there's a dispute, one party hits a button, they say there's a dispute, the others, they get to put in their side, comes in and puts forth their version of events, and it can even be done by video, just as Nick Szabo posited when we first started talking about contracts. So right away the dispute is joined fairly quickly, and then what might happen is sophisticated algorithms come in and analyze legal precedents from every jurisdiction and sort of digest them, print them out for the decision makers appointed who specialize in that particular area. He can render his decision, and then there would in fact be the right of a fairly quick appeal, because there's always a chance that a decision human will get it wrong, and there we have it, a relatively frictionless system. Of course, it's perfect, but just having it with the intent of being faster and specialized to the cryptosphere, I think is going to allow greater freedom of expansion in the cryptocurrency economy, which may be being held back because there isn't any particular legal redress now built into the system. So we need lawyers, of course, right? Banks are eradicated by Bitcoin, so I don't think lawyers would be either. And I don't think that, I mean, I do think that lawyers serve important business planning and litigation functions that likely won't go away completely, even in a system that was wholly algorithmic sometime far into the centuries in the future. But I think under such a system, lawyers are able to provide even better client service in a more efficient and technologically advanced legal system. So that's just sort of a crypto legal system, as I'm calling it. But what I think is also going to happen is, because I think the lawyers in the room is, to the extent that the cryptocurrency legal remedies become more responsive, it's likely to push traditional law as well. And so not only would you have more efficient law that's tailored to the crypto sphere, but we're likely to also see sort of more responsiveness, maybe less friction in the larger legal system as a whole. And to my mind, that would be a good thing. But in any event, it would be a good conversation to have. I mean, in my jurisdiction, it was only in the last couple of years we were allowed to serve plea mail. Right? I mean, the other lawyers are not. Before then, you had to snail mail everything. But even if you sent a pleading attached to an email, a lot of times the opposing counsel will still require that you send it because they got to then respond later because it was actually put in the mail. So even though it was much more efficient, even though they already received it and read it, they still didn't count the time until someone had put it in the mail. And so we can get a lot faster and a lot more efficient, right? If it took 20 years to just go to email, there's a lot of improvements in the system. And really, all they deserve, right? They deserve to be heard, they deserve a fair hearing, and they deserve an expeditious resolution of their dispute. So ultimately, my hope is that this sort of cryptocurrency law would create a better system that's better for clients, better for commerce in the long run. Thank you. Any questions?
Building a framework where you have cryptocurrencies and legal law kind of it's very big words, it's not completely integrated or something. That often they are at opposite ends of how to resolve certain situations. So there seems to be a bit of a clash going on there as well. Could it be that the legal system will force a clash out of the crypto system?
Yeah, I think that there's likely to be sort of a symbiosis in that. But I think that what often happens in new areas is that the clashes seem really glaring because they haven't been really thought of in that way or addressed that way, and the law tries to, as he was saying, fit sort of imperfect parallels onto the system. But I think eventually it sort of rights itself and the appropriate mechanisms then become adapted.
So that's in the sense that the cryptocurrencies will lead the law.
Well, I think that they will. I think they're going to push the law to be faster and less and have less friction. That's my sense. Because if I'm involved in a significant commercial transaction and I look around and I have a choice between adopting a private remedy in the crypto sphere that I think is going to give me complete redress but cost me a lot less money and be faster, that's the one I'm going to pick.
Okay.
So that's, I think, going to then, if that happens, then the law will migrate like any editor and pick the features that are working over here. And it's not really that novel. People opt out of the traditional legal systems all the time, and they opt for arbitration or private resolution.
It doesn't seem to be tied to cryptocurrencies, this argument here is number one. There is already competition. Lex preparatoria could be brought back. Is here already. Right.
No, there is. People can opt out of the system, and people who are not lawyers tend not to think that way. But you can always, for a private resolution of your dispute, and if you have a good lawyer and you're structuring a transaction, you will, in fact, a dispute resolution methodology that's best suited to the concept that you're dealing with and the transaction. And so I think in that way it'll be sort of self-selecting.
Thank you.
Thank you very much for your speech. In what manner, in what way would you suggest to implement such a new system?
Sure.
Would you do that in a contractual, or how do you see that?
Yeah, I think, well, I see it could happen in two ways. One is contractually. My sort of larger view would be that there could be like a side that dealt only with the legal issues that arise from the cryptocurrency. And that whole legal system will be embodied on that sidechain. The whole process, which is getting the positions from the different sides and selecting the mediator or the judge, would all be handled by the software. And from a substantive standpoint, the precedents and the cases that are decided under that system will also be stored as data to be searched on that blockchain. So, or you could just create your own legal currency, like people have space currency, which I don't really understand, but I understand it's a thing, right? You could have your own legal currency that, in fact, be applicable to either specific or all of the cryptocurrencies. Anyone who had a dispute involving that particular currency would know automatically, unless they opted out, they would be going over to the sidechain that was implemented specifically for that very purpose. At least that's how sort of my view is evolving, how that actually would come out in practice. I'm sure that there would be hiccups and maybe better solutions as we thought more about as precedents come up. Because think about it, a lot of the established contract principles are going to work to be applied in the crypto, but some aren't, right? Because you have wallets, private keys, blockchains, things that really don't exist in other contract contexts. So there's going to have to be some morphing of the substantive law, I think, at the very least.
I have a question, and would you then sort of limit sort of legal infrastructure or the legal part of currency, would you limit that to the directly currency-related issues itself, or would you also extend it to the business transactions? Because this is basically what I was thinking when you giving your presentation. I was thinking the latter, that you recreate an entire legal framework on which the seat itself is the sort of anchor.
Yes, that would be that's my bigger picture idea, which is that it would apply to all the phases of the transactions, because otherwise, like I said earlier, people are just going to use Bitcoin to make payments, and then they're still going to have a 20-page contract.
Correct.
That goes along with their transaction.
A little bit with the last remarks you made. I thought, hey, does it only have to do with payment-related issues and problems?
Well, I think it depends on what the parties contract into.
Obviously,
right.
From a legal technical point, I
Sure.
would see it like this: that paying or using a particular currency, you are explicitly or implicitly agreeing to, but first of all, so many rules and regulations with regard to resolution of payments.
Right.
So technical payment related problems, your problem with your wallet,
exactly.
What. And then ultimately, depending on the sort of use that you're going to make with your currency, you could then go for extending the legal framework to the transaction itself.
Right. That's the latter is really what I intended.
What you could agree with your party, the recipient of your payment.
Right.
That you could then agree on certain terms and regulations for that particular, and in actual fact you could even extend it to an entire framework depending on the type of transaction. Now, if we're thinking aloud, one
workshop.
would think that if one is, for example, in international coal trading, you could have a specific framework dealing with sort of international coal or cargo trade, which would then make it ideally suited for parties that are involved in that type of transaction to then use that particular currency and that particular legal framework. Because otherwise they would now they're sort of shanghaied into the International Chamber of Commerce and all sorts of other very complicated legal arbitration colleges and what have you.
No, I totally agree. I think that was sort of inherent in my idea that there would be a specialist appointed to resolve it, and that sort of special laws would evolve as disputes themselves sort of played out. And if there's a particular subset of transactions, I would imagine that there would be a specialty.
You see, the interesting thing is that I was listening this week to a certain presentation of Ethereum, which seems seems to be a sort of overlaying sort of foundation or an for multiple currencies. A combination of that. I mean, we have to be careful that we're not only talking about Bitcoin, especially since we heard what we heard yesterday afternoon, which I didn't find very encouraging, all the problems related to Bitcoin, to be honest. I mean, but the principles that we're talking about and what you are thinking about, and the principle of having an Ethereum-like, whether it's Ethereum, I couldn't give a rat's ass what name or what framework we will eventually use, but serious technology providers that really have the capability of delivery and proof of authority. That would be a very interesting concept, I think.
I'm a big Ethereum fan of the other smart contract
Yeah.
programs. My larger point about that is that no matter how detailed you attempt to make the smart contract, you're going to have a certain percentage that are going to have disputes because something unexpected happened or because one of the expectations of the parties that wasn't explicit was left unmet.
I have two questions. One is about the Bitcoin themselves. The Bitcoin and cryptocurrency systems are by nature decentralized.
Correct.
Bitcoin by itself, or other cryptocurrencies with similar protocols, well, they allow to do only one thing, basically, to transfer Bitcoins from one owner to another one. This is the basic thing they do. And these are very decentralized. Clearly, behind this transfer, there could be, or better, than always, there is some transfer in the opposite directions of money, service, goods, and this could be object of a dispute. But the Bitcoin themselves are very simple transaction, and as far as I know, the only dispute that could be is that someone claims that the transfer is illegal because they were stolen. But in this case, I think well, to reverse such a transfer or to put the Bitcoin in a blacklist, you need somehow a centralized authority.
You need consensus.
Right.
Yes,
That's my point. Right. There
could be distributed one thing. And so how could this fit in this legal system? The second is similar, but maybe other have raised it. Is yes, if you use the protocol for contracts, basically, clearly you need also way to address this system. Probably the way that, well, this system, you may not have the correct term, is an arbitration system. The parts could agree to use this quick arbitration system in place of traditional law enforcement. And by the way, probably the same protocol or a similar protocol, already said, I think, but could also be used to save all the document of the legal dispute because, well, you use the same technology you are dealing with.
No, I totally agree. I actually think of Bitcoin much simpler. It's not just to transfer the coin, but it basically transfers data.
Yeah, exactly.
Transfers and stores data. And so a legal system is data, right? And so I think it could be accomplished pretty easily, but you're on a blockchain. But I think your point about decentralization goes to the whole very principle of Bitcoin, right? Which is to disintermediate the controlling authorities from the system. And since we as lawyers are in the habit of contracting a traditional system in circumstances for our clients where a better system exists, then this isn't really that different. And I actually take issue with the sort of trustless intermediary nomenclature because I don't think that there's no trust. I think that it's just a different kind of trust. Instead of trusting the government or trusting a bank, we trust the consensus software protocol that creates the consensus. And so there is trust, it's just a different kind of trust. So you're right. Well, thank you again.
Thank you.
Other questions?
Oh, okay.
No more? Okay.
Thank you. 5 minutes?
Yes, that's a good idea.
Okay.
I support that motion. Motion carries.